Ladies and gentlemen, I welcome all to my channel. I am Razia Ali, advocate. Today we are going to discuss about promissory note, how to draft promissory note, what are the loan documents normally collected by financier or bank, what are the things we have to look into before signing those documents. Supposing we want to give a loan to our relatives or our friends, what are the documents we can collect, what are the securities we can make, and how to suppose the people refuse to pay the amount, how to file a case, where to file a case, what are all the expenditure involved in this for filing these cases, whether we can sign as a surety, what are the liabilities to the surety, how to handle the misuse of the documents by the financier, or in what are the ways how they are misusing the documents, what is the interest, permissible interest to be charged for giving the loan. Suppose they collect excessive duty, excessive interest or excessive charges, or suppose they to exploit you, how to handle the situation are all discussed in this video. So let us see one by one through this video. So what is meant by promissory note? Supposing if your friend or your relative wanted to ask you to give you some money, hand loan, what will you do? Normally you will give this money out of trust, out of friendship, or out of a relationship. And supposing after 1 or after 1 month, after 1 or 2 months, or after 1 or 2 years, they may come forward to repay the amount. So in that case, if you want to put a pressure on them, or if you want to go to the court, then the court will ask you to show the proof. What is the document? What is the document you have to prove that you have given the loan? Like that, the court may ask. So if you have a promissory note, or if you have the promissory note got executed at the time of giving the loan, that will help you to file a case against the borrower, and you can also charge interest, or you can also recover the legal expenses which are all involved in recovering the money. So this is the loan promissory note is nothing but a loan document given by the borrower to the giver, stating that I have received this much of loan and I am agreeing to pay this much of loan on one particular date, or as and when it is demanded by you, and I agree to pay interest, or I agree to pay monthly interest this 6% or 12%, whatever it may be mentioned in this document. And it will also mention that I will also agree to pay the interest periodically or every month, like that. That also can be mentioned in this document. So simply saying the promissory note will contain only 4 or 5 lines. Promissory heading, it will have the heading like promissory note, then followed by then on demand I Mr. X promise to pay a sum of rupees 1 lakh to Mr. Y for the value received from him with interest 6% per annum. Like that, like that it will be mentioned in the promissory note. Thereafter, you will have to sign, put your signature in the below the text. Then you can also put a date and place. So now normally promissory note can be written in a small white paper. It is to be in which you will have to affix a revenue stamp to confirm the receipt of the amount. So it need not be, promissory note need not be typed in a judicial stamp paper or any other form. You need not go for registration and all. So simple small white paper and mentioning about these things with 1 rupee revenue stamp is sufficient to comply for the legal requirement to the promissory note. So when supposing a person asks you, or supposing you ask loan from a financial bank, normally in addition to this promissory note, they will also ask you to produce some title documents. Suppose you have a property, and if you are going for a loan for about heavy, very big amount, then the bank or financier may insist you to produce the title deeds of your property. So you can, similarly, if your relative or friends ask you to give a very big amount, so you can also insist them to produce their property documents like sale deed, patta, and other title deed relating to their property. So you can have that document. Along with the covering letter stating that I have received this much of loan, and for as a security for the repayment of this loan, I am depositing all that my title deeds mentioned below 1, 2, 3, sale deed, patta, whatever it may be. So this will, if you collect a letter like this, or if you give a letter to a bank or financier, it will amount to a mortgage. Mortgage means you are giving the property as a security to the financier or the bank or to the loan giver, out of which, in case you fail, the borrower failed to repay the loan, then the bank or financial institution may brought your property for sale through court, and out of the sale proceed they can recover the amount. So this is the way through which security can be obtained from your friend or relationship. Similarly, it will also be obtained by the bank or financial. So supposing your friend or do not have any property, then you can ask for the check. Normally, whenever you approach a bank or financier, definitely they will ask you to produce some or 5 or 6 checks with your signature. In many cases, what the private financier they will insist your wife to open a bank account, and they will collect 5 or 6 checks, blank checks, collect from the wife's bank account, and they will ask you to put a wife's signature, so that they will keep this check in their hand as a security. Once the amount is not repaid, or they defaulted in making the payment, they will fill the check and deposit it in their bank account, and they will, once the check is returned, then they will file a criminal case in the magistrate court. This is the practice they are following in many financiers, even in nationalized bank is also adopting these things. So here the pressure will be more. So supposing if a person failed to repay the loan, or refused to repay the loan, then the one and only remedy available to the bank or financial institution is to file a civil suit. And they have to file a civil suit, they have to wait for 2-3 years, and thereafter they have to get a judgment. Once the judgment is obtained, then if the borrower has any property, then they can file a petition to attach the property, and they can recover the money. Supposing the person do not have any property, then this judgment or decree will not help you in any way. So mere paper, it will be a mere paper, and you will not be in a position to recover the money. So to sort of avoid any this kind of things, most of the financiers are demanding the borrower to give some blank check with signature from the borrower or from their close relative, preferably from the wife, so that they can comfortably file a criminal case and put more pressure on them to repay the amount, and they are recovering the money. So once the criminal case is filed, the problem is, for each and every hearing, the drawer of the check, that is who issued the check, has to go to the court for 1 or 2 years till the criminal case is conducted in the court, and ultimately the court may impose fine to the extent of twice the value of the check amount, or imprisonment that may be extended to up to 2 years. So when there is a threat for punishment and fine, and then it will automatically put pressure on the borrower to repay the loan as early as possible. In addition to that, one of the most difficulty thing is that when a criminal case is filed, for each and every hearing, the borrower who issued a check has to go to the court. That is a headache. There is a very big headache to those people, because moreover, in most of the cases, the financiers, when they collect a check from Chennai, they purposefully open an account in Mumbai and file a case in Mumbai, and so that they will put a pressure on the parties to come to the Mumbai court for each and every hearing, which will be a very hard effort, and the borrower may not be able to tolerate all this torture, and automatically he will come forward to repay the loan, like what this practice was prevailing. So whenever you receive a loan from a financier and your other things, please try to avoid issuing a check from your wife or from any person, at least from your wife, because ladies may not tolerate all these things. In many cases I have seen in Saidapet court and Egmore court where the borrowers, the financier purposefully demanded the checks from their wife, and they have filed a case in the criminal court, and they are putting pressure on their wife to come to the court, and ultimately that automatically causes husband and wife relationship, and they even go for divorce level. The matter is going up to the divorce level. So please, as much as possible, it is better to avoid issuing a check, and it is always advisable not to issue any check by your wife relative, particularly from female members, because it will be a great headache in future. Then regarding the surety, I wanted to make one clarification. In many cases, what the people do know, they will call, friends will take you to a financier and they will borrow a loan. Then you may be a government servant, or you may be an employee from a reputed MNC company. The financier will simply ask you, sir, please sign this as a witness, or to confirm that he is received a loan. Like that, they will insist. If you put a signature in the promissory note, they will put a word. They will write one more sentence in the above your signature saying that surety. So once you sign as a surety, you will have to answer the liability of the borrower. So surety means who is guaranteeing for the repayment of the loan. So supposing if any persons, any of relative ask you to sign as a surety, you please bear in mind that you are taking a liability of the borrower, and in case he fails to repay the loan, you will have to repay the loan with the interest, and your property is also liable to be attached. So this is the consequences of surety. So whenever your friend or relative asks you to sign as a surety, please be careful, and if it is in case it is really required, like if supposing you are a father or mother, or if you are a husband or a wife, or your son or daughter, then in that case for close relatives you can sign as a surety, because you have to take the responsibility of your close relative. But don't take risk don't put a signature as a surety for outsiders or friends, because they may not be in a position. They may not be in a position. If they fail to pay the repayment, the liability will fall on your head, and you will have to answer for their claim. Then another question is regarding the interest. In many cases, what the people don't know, most of the financiers are collecting Knanthu Vatti, meter Vatti, and in proportionate level, and they are exploiting the borrowers. So in Tamil Nadu there is an act has come, Tamil Nadu Knanthu Vatti Prohibition Act. This act says that nobody should charge any interest more than that of the nationalized bank level. So normally the nationalized bank level banking charges about 9% or 10% per year as the interest. It is not per month. For 1 year, maximum interest chargeable by the private bank is 12% only. It will not charge more than that level. So if any person asks you to pay 10% per month, 5% per month, that will be an interest more than that of the amount prescribed by the nationalist bank. So automatically it will amount to offence under the Knanthu Vatti Prohibition Act. So in case if you are getting repeated torture from any financier for Knanthu Vatti and other thing, you can directly go to the police station and you can file a criminal complaint, and they will definitely help you, and they will definitely take necessary criminal case as against the financier, and they will safeguard your interest. So whenever if you have any torture from financier for Knanthu Vatti, and you have every right to approach Chief Minister or higher police officers or Commissioner of Police or Superintendent of Police or concerned police station. They will help you, and they will register the complaint and help you from the torture or problem as from the financier. Then regarding the filing of the case, when a promissory note is signed, the case has to be filed within a period of 3 years. Supposing on 1st January you receive a loan and execute a promissory note on 1st January 2020, then the case has to be filed within 3 years, means 21, 22, 23. From 21 to 2023, the case has to be filed. If the case is not filed within 3 years, then it will be barred by limitation. So you cannot wait for, you cannot sleep for 5 years, and after 5 years you cannot go to the court and file a civil suit on the basis of the promissory note. So limitation period for every promissory note is only 3 years. So normally what to avoid, to extend the limitation, people are adopting some techniques that is called acknowledgement of liability. So supposing if you gave they gave a loan on for 1/1/2020, and if you make a payment in 1/1/2022, then they can file a case within 3 years from the last date of payment. So that is in the meantime you have received one payment in 2022, 1/1/2022, then the limitation period will be automatically extended from the payment date. So up to 2025 they can file a case. Similarly, if they are received in all financial bank and financial institution, normally collects the signature in blank signature in the acknowledgement form. Acknowledgement form is nothing but acknowledging the debt liability. So in the acknowledgement liability form, it will be written like this: I have received this much of loan, my loan amount and interest as on date accrues this much of amount, but they will not put a date on the form. So whenever the bank or financial institution wanted to extend the limitation, they simply fill the form which was signed already by you. So by signing that form, by getting the signature from the borrower, they are automatically extending the time limit. So these are all the ways. So whenever a promissory note, if your friends ask you or relatives ask you a loan, you can get them a promissory note. If the loan amount is high, you can also collect the title property documents, and you can also collect a check. That will also help you to file a criminal case as against the borrower in the event of their failure to repay the amount. Similarly, the banks also adopting, or financial institutions also adopting the same procedure: promissory note plus check and property documents, through which they are mortgaging the property and getting strong security for the repayment of the loan. So I hope this video will be useful to you. I think I have answered all your queries regarding the promissory note, surety, and the torture and exploitation prevailing on the basis of the surety by financier. I hope this video will be helpful to you and friends who really suffered with this loan transaction. In case you have any doubts or clarification or additional legal advice, you can contact me. I can help if it is possible. I can give you the required legal advice, and you can clarify your doubt if any. You can continuously watch my video. Knowledge is power. Legal knowledge will not only give you the power, but it will also give you strength and confidence in your life. That will help you to go for a higher level. So you can watch my channel. I have two channels. One is Rasyak Sattam Arivom, which is in Tamil language, and Rasyak Law Tube is a English channel. So you can just write Rasyak Law Tube or Rasyak Sattam Arivom in Google. Automatically my channel will open. From that channel you can select any videos on any topic or any playlist through which you can get through that video you can clarify your doubts and develop your knowledge. In addition to that, if you have any specific queries, doubts, clarification, legal advice, you are always welcome, and you can contact my cell number, and if it is possible I will give you clarify your doubts. I will come again with another topic. Until then, goodbye. Razia Kali.